So here's a jury of my peers. Good old Dexter, good old Blue. We got a little puppy here, Malcolm. Hey, Malcolm. Who else do we have? Good old Yeta, good old Modoc, good old Jiminy Jacks, good old Panda Bear. Hey, Panda Bear. Panda Bear's getting big and strong. Don Carlos fucking hiding underneath the thing. So I kind of want to finish reading it. You got little Lily who's outside. You got 4 other ones in that other side. Natty Nat, Mufasa, Simon Lulu. That's all one name. And Callie, the dog. Should we go see him? Let's take a look at him. Fuck it, you know. Who's all my peers here? Who at least can listen to me so I can articulate my perspectives? This shit is fucking outrageous. This shit is so fucking insane. It's not even funny. Well, you can't sue them. You gotta do a habeas corpus thing. Callie. Natty Nat. Hi, Natty Nat. Tupac. What's up, Tupac? Tupac with his little tail shaking. And Simon Lulu Mufasa. Are you breaking stuff? You better be on your best behavior, man. All right. So that's my audience. Oh, okay, little Lily. Can't forget little Lily. Can't forget little Lily. A lot of my dogs come out. I got a lot of black dogs, so it's like he's like an orange albino. He's like one of the ones that come out orange. Stay in there. So I kind of went on a little tear there. I kind of want to read this little fucking thing. So let's read this thing. Let's carry on with this thing here, huh? If Mr. Masters seeks damages under 42 U.S.C. 1983 in connection with a criminal conviction, he must allege facts in the Second Amendment complaint to show that the conviction has been reversed by the Colorado Court of Appeals or otherwise deemed invalid. Otherwise, the constitutional claims which challenge the legality of his arrest and conviction may be barred by heck. See Callan v. Wyoming Department of Corrections, 10th Circuit case, 2015, unpublished. Unpublished? How in the world can you cite an unpublished fucking decision? Oh, this is a decision that, well, nobody even knows about. But we're going to go ahead and reference it. It's a 1983 malicious prosecution claim was barred by heck, where there was no indication that the plaintiff's conviction had been overturned. Burden v. Wood, another 10th Circuit. This is their own courts. We went ahead and threw these other cases out back in 2006, and then this other case in 2015, and then Heller's 1994, or Heck v. Heller. Burden v. Wood, false arrest claim barred by heck, where plaintiff was convicted of the charged offense and conviction had not been overturned. 11th Amendment immunity. To the extent Mr. Masters asserts 1983 official capacity claims for monetary relief against defendants Gilbert Roman, Michael Gonzalez, Brian Boatwright, who are state court judges, and against defendant Ann Kelly, who is the district attorney for the 12th Judicial District, the claims are construed as claims against the state of Colorado. See Hafer v. Milo, 1991, Romero v. Boulder County DA's office, 10th Circuit, again, 2004, unpublished. Recognizing that a district attorney is a state officer under Colorado law, the state of Colorado is protected from suit by the 11th Amendment. See Will versus Michigan Department of State Police, 1989. Why do we have 1983 claims if every one of these guys, Meade versus Grubbs, again, 10th Circuit, 1988. You're going fucking goddamn 3 decades back. The 11th Amendment is not a jurisdictional bar to suit if, 1, the state waives its sovereign immunity, 2, Congress has abrogated the state's 11th Amendment sovereign immunity. Yeah, with the 14th Amendment and plus the Supremacy Clause. 3, a plaintiff sues state officials in their official capacities, and the plaintiff's suits seek prospective relief for the official's ongoing violation of federal law. So, oh, they're raping me and they keep raping me. That's you're allowed to fucking file. You can file that you're being raped and you keep on being raped. Harris v. Owens, again, 10th Circuit, 2001 case. A lot of their own fucking decisions. State of Colorado has not waived its 11th Amendment immunity. See Grease v. versus Colorado, GRIESS, 10th Circuit, 1988. And congressional enactment of Section 1983 did not abrogate 11th Amendment immunity. See Kern v. Jordan, QUERN v. Jordan, 1979. Accordingly, any 1983 claims for monetary relief asserted against the defendants in their official capacities are barred by the 11th Amendment. The whole point of the 1983 claim is that the 11th Amendment is tailorly made. If they deprived you of your fucking rights, then you could fucking sue these guys. Now they might say they didn't use an argument which I used, so I'm not sounding like I'm unreasonable. It says in 1983 that you're not allowed to claim a judicial officer as a part of the suit, and then the definition of a judicial officer is magistrate or a judge. And so, therefore, strict construction, if you just read the fucking rules, which apparently nobody does around here, if you just read the rules, then the judge and the magistrate is excused. The star player is exonerated, but not the supporting players. Well, guess what? That means Gilbert, Roman, Brian, they get to fucking walk away, but the damn DA and the cops, they don't get to fucking walk away. They don't get to fucking walk away. They're not a judge, and they're not magistrates. Judicial immunity. Let's see, we already mentioned this. No. This is 12 pages, too. They say we have to listen to the pro-state people. We're not even going to ask for them to respond. This is the court system doing the work for the defense. I mean, my God. They're not going to give me a fucking lawyer. They're not going to give me a goddamn judicial expert or an advisor. We're going to sit there and shove a liar's lie down everybody's fucking throats, and then we're going to sit there and put 12 pages worth of stuff in defense of the other. This is so asymmetrical warfare, it's not even funny. Gilbert, Michael, Brian Boatwright are state court judges entitled to absolute immunity from personal monetary liability for actions taken in their judicial capacities unless they acted in the clear absence of all jurisdiction. See Morales v. Waco, 1991, Stump v. Sparkman, 1978. We're going to fucking quote Stump v. Sparkman. Yeah, that case is where the daughter gets fucking sterilized. They tie her tubes up because the mother lied and the judge allowed it, and then the judge gives immunity to the doctors. Hunt v. Bennett, again, another 10th Circuit, 1994. Judicial immunity is not overcome by allegations of bad faith or malice. Morales, 502 U.S. at 11, or an assertion that the judge acted in error or exceeded his or her authority. That's weird that they have all these fucking case law arguments about how the judges can, but they didn't mention it's part of the fucking law. It's in the wording of the law itself. But the judge is the one that's most in the position of depriving somebody of their fucking rights. And 1983 is you go after somebody within the color of law. How are they not in the color of law? So it's like they have to kind of be fucking the goddamn state, but kind of not be state. No, if they're the state, they're definitely acting under the color of law. So we're going to say 11th immunity, 11th Amendment. But then we're going to say, well, hell, they got judicial immunity anyways. Look at all these cases. And another 10th Circuit case. And also see Stump, 435 U.S. at 1105. So if a woman comes in and says, hey, sterilize my daughter, and the judge signs off on it, well, the judge isn't to blame. He just signed the fucking goddamn warrant against her fucking tubes. He just signed the fucking document that said that the damn doctors get immunity and they can't be sued either. Because Sparkman's going to sue everybody with this shit. And they're going to say, no, you can't sue the judges and you can't sue the doctors. Even if, like, he fucked up, even if he had made a bad decision. Get the fuck out of here, man. If he made such an egregious, disgusting fucking decision, he needs to be held to an account. There's also the argument about that there's appeals courts, right? So he has to obey the appeals courts. He already has judicial review. Morales, or an assertion that the judge acted in error, see Stump, they're going to fucking actually goddamn quote Stump v. Sparkman. Can you believe that? Further, a judge acts in the clear absence of all jurisdiction only when he or she acts clearly without any colorable claim of jurisdiction. He acts in the clear absence of all jurisdiction only when he or she acts clearly without any colorable claim of jurisdiction. Snell v. Tunnel, again, 10th Circuit opinion, 1990. Is this published? Can we read this? Snell versus Tunnel, Tunnel decisions. Mr. Masters does not allege facts in the amended complaint to show that the defendant judicial officers engaged in extrajudicial conduct or acted in the clear absence of all jurisdiction. They acted in the clear absence of all jurisdiction. Jesus Christ, this is so extrajudicial, it's not even fucking funny. Furthermore, 1983 expressly disallows injunctive relief against a judicial officer for an act or omission taken in such officer's judicial capacity unless a declaratory decree was violated or declaratory relief was unavailable. See Knox v. Bland, 10th Circuit, 2011. Although we have previously said that a plaintiff may obtain an injunction against a state judge under 42 U.S.C. 1983, those statements were abrogated by the Federal Courts Improvement Act of 1996, which provides that injunctive relief against a judicial officer shall not be granted unless a declaratory decree was violated or declaratory relief was unavailable. Also see Swain v. Seaman. Oh, of course, they're all about the Seaman. 10th Circuit Court 2012, unpublished. Another fucking unpublished opinion. Oh, I'm just going to cite this opinion that nobody's ever heard about or seen, but we have it in our books in this at the bottom of the fucking file cabinet in the damn fucking basement of the courthouse. And then we're going to quote it too. To be sure, Mr. Swain does mention correctly that courts generally recognize an exception to 11th Amendment immunity for plaintiffs seeking prospective relief from state officials. But Mr. Swain forgets that Congress expressly disallowed injunctive relief against judicial officers unless a declaratory decree was violated or declaratory relief was unavailable. Citation and quotation marks omitted. YAS v. New Mexico, 10th Circuit, 2010. YSAIS. Judicial officers are explicitly immunized not only against damages but also against suits for injunctive relief under 42 U.S.C. Section 1983. The allegations of the amended complaint fail to show an entitlement to relief against defendants Roman, Gonzalez, and Boatwright. Well, the judges get away with their shit. Now, prosecutorial immunity. Mr. Masters' 1983 claims asserted against defendant District Attorney Ann Kelly in her individual capacity for monetary relief appear to be barred by prosecutorial immunity. Prosecutors are entitled to absolute immunity in Section 1983 suits for activities within the scope of their prosecutorial duties. See Imler v. Pachtman, P-A-C-H-T-M-A-N, 1976. See also Butts v. Economou, 1978. Butts v. Economou. Initiating and pursuing a criminal prosecution or acts that are intimately associated with the judicial process. Snell v. Tunnel, 10th Circuit, 1990, quoting Imler. Mr. Masters alleges in the amended complaint that defendant Kelly denied him a fair trial, suppressed evidence, allowed witnesses to perjure themselves in court proceedings, which she did, and otherwise engaged in conduct in connection with his criminal trial that is protected by prosecutorial immunity. It is not, although prosecutorial immunity does not preclude an official capacity claim for prospective injunctive relief, Mr. Masters does not articulate a basis for prospective injunctive relief against defendant Kelly. To the extent Mr. Masters seeks an injunction preventing defendant Kelly from ever having any further involvement in any pending or future prosecutions involving him, such a broad restriction on a state district attorney's prosecutorial powers would improperly infringe on state functions. See Carbajal v. Holman, 10th Circuit, 2012. The allegations of the amended complaint fail to show an entitlement to relief against defendant Kelly. Claim of witness perjury. Not only are we going to cover up for the DA and the judges, we're also going to cover up for the fucking lying-ass witness. Mr. Masters alleges that defendant Joe Canty, who was the state's main witness in plaintiff's criminal proceeding, perjured himself. In Briscoe v. LaHue, 1983, the Supreme Court held that all witnesses enjoy absolute immunity from civil liability under Section 1983 for their testimony in a prior trial. Absolute immunity? Why would anybody get absolute immunity? Anytime they say we have a right to freedom of speech, the right to petition, the right to bear arms, they always say that it's not absolute freedom. You don't have absolute anything. Why would you have absolute power if you don't have absolute freedom? If you're going to side with absolute power or absolute freedom, you side with power. Or you're saying you're the oppressor. It's just the oppressor versus the oppressed. Briscoe v. LaHue, 1983. See also Hunt v. Bennett, 10th Circuit, 1994. Therefore, the allegations of the amended complaint